Welcome to video 2 in our series on venue. In this video, we are going to focus on 28 USC 1406. 28 USC 1406. Improper venue. What happens when the plaintiff chooses the wrong venue district? What happens? Well, 28 USC 1406 anticipates and answers this question. Congress anticipated the possibility that venue would be tested, right? And what I mean by that is, I don't mean that any practitioner is intentionally filing in the wrong venue, but it's going to happen, right? And if we can anticipate that it's going to happen, what do? Congress said, we're going to give you 28 USC section 1406 as a cure. It is a curative statute, not a punitive statute, right? Punitive as in you bad practitioner, you filed in the wrong venue, you don't get to practice law anymore, right? Or you don't get to file this case again because of this mistake, right? No. 1406 is curative. It allows a court to do one of two things. It gives the court some discretion. It allows the court to dismiss the case without prejudice, which means you get to go file it elsewhere, right? Or more commonly, it allows the court to transfer the case to a district where the action could have been brought in the first place, right? So wrong venue, not a problem. We can dismiss it without prejudice. You can go to the right venue location and refile and move on. Or you can have the case transferred to the right venue location, right? It's curative. So let's take a look at 28 USC 1406, wrong venue. 1406A, the district court of a district in which the case is filed in venue is wrong, right? The court shall dismiss it now. Shall dismiss it. Or if it be in the interest of justice, transfer it to any division or district where it could have been brought initially. So, shall dismiss it, or if it be in the interest of justice, transfer it. That's really pretty simple, huh? Yeah. Okay. B, nothing in this chapter shall impair the jurisdiction of a district court of any matter involving a party who does not interpose timely and sufficient objections. C, as used in this section, the term district court includes District Court of Guam, District Court of Northern Mariana Islands, etc., etc. But this is what happens if you file it and you file it in a place where the jurisdiction is wrong. Let's look at an example. Imagine a plaintiff sues a Florida corporation in the Northern District of Illinois. Okay. Plaintiff sues Florida Corporation, Northern District of Illinois. The suit is based upon a car accident that happened in Miami. Are you following? Right? If you want to track it, get some paper or whatever you're using to track it, you can track it. Illinois has nothing to do with the case. Illinois has nothing to do with the case. the venue's improper. The Illinois judge can either dismiss without prejudice or, in the interest of justice, transfer the case to the Southern District of Florida, where venue was proper. Got it? Want to go over it again? No? Feels good? Okay, well, then let's keep going. That's all I have for improper venue. So let me go back, because that's all that, right? There's nothing else to improper venue, to 1406. If the venue is improper, the court shall dismiss the case. Or, if it be in the interest of justice, shall transfer the case. That's it. Yeah, there's your example. We now move to 28 USC 1404, the transfer, right? Because you're probably thinking, okay, well, yeah, we'll transfer. Well, what if the venue is proper, but it's inconvenient? What if the venue is proper, but it's inconvenient? So hold on tight, because I'm going to go back and then I'm going to come forward, and I don't want anybody to get whiplash. 1406 is improper. It's improper. This is the wrong place. 1404 is no. It's proper, but it's not convenient. Oh. Okay. It's not convenient is not the same as it being incorrect. It's not convenient is exactly what it says. It's just not convenient. So let's see what 1404 says about it being proper but inconvenient. 1404A, for the convenience of parties and witnesses in the interest of justice, a district court may transfer any civil action to any other district or division where it might have been brought, or to any district or division to which all parties have consented. Right? Because I can consent to venue. That's why, if it's not raised as the first responsive pleading, it gets waived, right? 1404B, upon motion, consent, or stipulation of all parties, any action, suit, or proceeding of a civil nature, or any motion or hearing thereof, may be transferred in the discretion of the court from the division in which pending to any other division in the same district. Transfer of proceedings in rem brought by or on behalf of the United States may be transferred under this section without the consent of the United States. Okay, that's 1404. 1404 also has a C and a D, right? 1404 also has a C and a D. A district court may order any civil action to be tried at any place within the division. D, transfers from a district of the United States to the District of Guam, the District Court of the Northern Mariana Islands, or the District Court of the Virgin Islands shall not be permitted under the section. Okay, so when in doubt, go to the code book that gives you the procedure. Go to the code book that gives you the procedure. You don't have to ask the managing attorney where's venue proper. You don't have to ask, oh, you've assigned me this motion to transfer. Under what provision am I using? Go to the federal rule. I mean, these aren't federal rules, but go to the statute that gives you the direction. Example 2. Suppose an accident happened in Orlando. The key witness, doctors, police investigators, let's say, are located in Miami. Both the Middle District, that's Orlando, and the Southern District, that's Miami, are proper under 1391. Okay. We had the accident happen in Orlando, which is the Middle District. That is 1391B2, substantial part of the event, right? And we've got the witnesses, the doctors, the police investigators, all of those people are in the Southern District, which is Miami. Both of those venue points are proper. That means that venue is not wrong like 1406, but it's proper under 1404. But one form is clearly more convenient than the other, right? The witnesses are there, the evidence is there, the local interest is there. So that would allow the court, on the motion of the defendant, to transfer the case from the Middle District of Florida to the Southern District of Florida. Get it? Proper. 1404 is proper. 1406 fixes mistakes. That's where it's improper. 1404 adjusts for convenience. Under 1404, a federal court may transfer a civil action for the convenience of the parties and the witness in the interest of justice to any other district where the case could have been brought, or where all the parties consent, but it still must be a place that is proper, right? This provision gives judges broad discretion to balance fairness and practicality. Balance fairness and practicality. So let's look at the McMahon versus Eli Lilly case to see what 1404 looks like in action. Let's look at McMahon v. Eli Lilly. I've given you this style of the case if you want to pull it up if you hadn't read it already. And let's see how 1404A is applied. What's going on in McMahon versus Eli Lilly? Well, the court is going to try to balance two categories of interest. The court is going to try to balance two categories of interest. The court is going to try to balance private interest and public interest. Private interest includes where the events and the evidence occurred, where the witnesses live, availability of the process. Public interest includes local interest in having localized controversies decided at home, right? And the form's familiarity with governing law and avoiding unnecessary burdens on courts with little connection to dispute. So the court in McMahon is trying to balance interest in two different categories. Let's look at the facts. Again, not going to go deep into the facts. We're not going to go deep into the facts, but we've got to address some of the facts just to get a sense of how the court is applying 1404A. Plaintiff alleges that her mother ingested DES while pregnant. Exposure to DES in utero, that's why the baby is still inside, purportedly resulted in uterine and cervical malformities. Now, there's a lot more, right? But we're just going to pick up some highlights. September 14, 2007, the plaintiff and her husband, Michael McMahon, filed a 7-count complaint in D.C. Superior Court. Collectively, the plaintiffs seek $3 million in compensatory damages and $3 million in punitive damages, right? September, we filed a lawsuit, 7 complaints, $6 million total, $3 million compensatory damages. Those are actual damages, and 3 million in punitive damages. Those are damages intended to punish bad behavior and prevent bad behavior, because hopefully the punishment is enough to deter other bad actors. Okay. Just a few more facts, not many, but just a few more facts. On January 8, 2008, the parties appeared before Magistrate Judge K for an initial status hearing, at which time the court set dates for discovery and other matters, right? And the discovery dates were going to close on September 22nd, 2008. So you've got your interrogatories, your request for information, your admissions, your depositions, right? All of that stuff needed to be conducted within the next 8 months, because discovery was going to close on September 22nd, 2008. 4 months after the initial status conference, right? 4 months later, so in May, the defendant, which is the drug company, filed a motion to transfer the case to the District of Massachusetts. You've got an 8-month discovery window open. You wait 4 months, or the defendant waited 4 months before they filed the motion to transfer, right? Ready? And they filed it based not on improper venue, but they filed it on venue not being convenient. You know me, I love my tables, and I've created this method of fact element mapping so that we can literally line by line give birth to our analysis. So what are some of the facts that we're going to look at? Again, we're not going to do all the facts. We're just going to do, I think I only picked 8, but we're not going to do all 8 because you'll have the slides. Let's go to fact 1. Plaintiff Judith alleges that her mother ingested DES while pregnant. Okay, so where does that connect? Connection of the operative facts to possible venues where the events occurred. So I know that I'm good there, right? I know that I'm good there. The injury originated from events in Massachusetts, not DC. So that's going to anchor the case, and its center where? In Massachusetts. Okay. Now, again, remember, we're not looking for improper venue. We know that the venue is proper. What we are arguing, or what the defendant is arguing, is that while proper, it's inconvenient. All right. So let's go to 4. Fact. Collectively, the plaintiffs seek $3 million in compensatory damages and $3 million in punitive damages. Where does that connect? What's going to be the burden on the court in DC? Because that's a significant amount of change. Right? It's not like DC is going to have to pay it, but in order to get to that number, that's going to take up some significant DC court time, right? Because in order to get to that number, I'm going to have a lot of witnesses. I'm going to have a lot of evidence. I'm going to have a lot of conversation, a lot of discussion, a lot of that 3 million, right? And compensatory damages, that's a lot of hospital bit, right? There's a lot that's going to have to take place in order for this case to be properly adjudicated. And if we do that in DC, that's going to take up a lot of DC time. So how does that play into my analysis? I'm on line 4. The large damages sought highlight the seriousness of the dispute, right? And that doesn't strengthen DC's interest, right? Massachusetts is going to have a much stronger interest because if that amount of damage was done to a Massachusetts citizen, and there's other parties who are alleging that they've had some damages as well from DES, then Massachusetts really has an interest in adjudicating this case, right? They've got a vested interest in adjudicating this case. What does that ultimately lead me to? That leads me to some pretty good support for the transfer to Massachusetts. Let's look at fact number 3. On September 14th, 2007, the plaintiff and her husband filed the 7-count suit in DC claiming negligence, strict liability, breach of warranty, misrepresentation, loss of consortium, etc. Right? The DC filing reflects the plaintiff's choice, right? They chose it, but that choice is going to receive less deference when the form, that's DC, has minimal connection to the underlying events, right? If there was negligence as claimed, where did the negligence take place? Massachusetts. If you read the case, right? Massachusetts. If there's strict liability, where should that be applied? Where the action is taking place. That's Massachusetts. If there's a breach of warranty for the medication, where is that going to have its greatest impact on the citizens of Massachusetts? Ultimately, what is that outcome? It weakens the argument to keep the case in DC and strengthens the argument. It supports the argument for the transfer. Let's do just one more. Let's do number 8. The plaintiffs have filed a response and the defendant a reply. The court now turns to the motion. Here's the court balancing private interest, public interest, right? Private interest, public interest. Both sides were heard. The court proceeded to balance convenience, cost, and justice. The record revealed that nearly all of the operative facts and the witnesses were Massachusetts based. So what was the outcome? The court granted the transfer to Massachusetts, right? 1404, venue's proper, but it's not convenient because venue is a tool for the defendant. It's going to be the defendant who's going to raise that motion to transfer under 1404. The court is going to balance the interest, and in balancing that interest is going to make a decision. And in this case, Judge Collier began by emphasizing that 1404 gives federal courts broad discretion to decide when convenience and fairness justify transfer. Even when the chosen form satisfies 1391, right? Venues proper. The task, according to Judge Collier, is not mechanical. It requires the court to balance private interest and public interest factors, right? And that's what this court did when they decided that it was in the interest of justice that the case be transferred from DC to Massachusetts. Well, what were the private interests that the court took into consideration? Private interests, convenience of the witnesses. Number one, the court found that the core witnesses, that's the plaintiffs, treating physicians, the plaintiffs, medical experts, and family members, were located where? In Massachusetts, where the plaintiff lived, where the plaintiff received treatment, and where the plaintiff held her medical records. Okay, well, what's another private interest? Access to evidence. We just talked about the records. What's another private interest that the courts considered? Convenience of the parties. The plaintiff resided in Massachusetts. The defendant, though a national corporation, had its key witnesses and records, right, near the exposure site, which was Massachusetts. The court noted that litigating in DC would impose greater hardship on both sides, making Massachusetts, for this case, the center of gravity. Okay, well, let's look at the plaintiff's choice of forum. Got it. Although a plaintiff's choice of forum typically receives substantial deference, right? Benefit of the doubt. That deference is significantly reduced when the chosen forum has minimum factual connection to the case. Minimal factual connection to the case. In this case, the only link to DC was that Eli Lilly, the drug company, did business in DC. And they did business there generally, right? So consequently, how does that support keeping the case in DC? It doesn't. All right, well, okay. Well, let's look at the public interest factors that were considered. Local interest in the controversy. The court underscored that Massachusetts had a legitimate and direct interest in resolving injuries suffered by its residents, allegedly caused by a product marketed in its jurisdiction, right? The District of Columbia, by contrast, had no meaningful stake in the dispute. Therefore, the local interest factor strongly favored the transfer. Let's look at public interest factor number 2, familiarity with the governing law. The substantive claims were governed by Massachusetts tort law, not DC law. A Massachusetts federal court would therefore be more familiar with the controlling legal principles and better positioned to apply its own law correctly and efficiently. Okay. Public interest factor number 3, court congestion and administrative burden. The DC docket was notably congested while Massachusetts had a lighter civil docket. Let's look at the public interest of justice. Judge Collier concluded that the interest of justice demanded transfer. Every meaningful connection to the event, the witnesses, the law, the public interest, all of it pointed to Massachusetts. Leaving the case in DC while venue was proper would serve only the plaintiff's tactical preference. Hold on. That's not to be admonished, right? It's not to be admonished. That's the tactical preference. But for judicial efficiency, it just made sense for the case to be transferred to Massachusetts. Yeah, does that make sense? Okay. Here's the conclusion. After balancing all the factors, that's the private and the public factors, the court overwhelmingly favored the transfer. While the District of Columbia was proper under 1391, it just was not the most appropriate or the most convenient. So the defendant's motion was granted. This pause is intentional so that you can process that through. When you line up the facts, the case had almost no connection to DC. The alleged exposure, medical injuries, witnesses, the governing law, right? Under 1404A, the most convenient place was going to be Massachusetts. So Massachusetts it was. The takeaway from McMoon versus Eli Lilly is 1404 gives courts discretion to move a case when convenience and justice clearly favor another district. The plaintiff's choice of form does matter, but it carries less weight when the form has no real connection to the events. Again, right? Remember the three aims of venue 1391. Fairness was one, efficiency was another one. So this was not an error, right? There was no error. The venue was proper, but this was an adjustment for justice sake. That's McMahon. Yeah. Take a moment. You want to think about it. If we feel good about it, we can stop right there. Video 3 is going to address common law form non-convenience. Video 3 is going to address common law form non-convenience. There's not a statute associated with this because this is common law. This is a topic in and of itself because you'll learn that this is a judicially created doctrine. Now, I'd hoped we'd have an opportunity to get to Erie Railroad case, the Erie Doctrine, because the Erie Doctrine is all about general federal common law, right? Don't know that we're going to have time to do that justice. And so I'm going to defer and leave that to your federal jurisdiction professors, right? But understanding as we go into video 3, we're not going to be referring to a congressionally enacted statute. We're going to be referring to a judicially created doctrine. I hope to see you in video 3. And in the meantime, have the absolute best time learning how to maneuver in the best profession ever.